Well, hello, 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 and good evening. Welcome. Tuesday True Crime, and an unexpected ability to actually do a true crime tonight because, well, as some of you may know that joined me Monday morning, we were disappointed with a delay, a delay again in the Sarah Boone trial. But, you know, based on the last 4 years, should we really be surprised? Should we really be surprised, people? Like, we knew something was going to happen. I mean, just Friday, like the defense lawyer wasn't even able on Thursday evening to practice law in Florida and he had to straighten everything out before he talked to the judge on Friday. Yeah, so like to think that things aren't going to get crazier, well, you know, even with Hurricane Milton on the way to Florida, Judge Kranick decided to not have the jurors worry about getting ready and all of that, and to just decide to delay the whole thing by a week. So Monday we'll start again. And lucky for you guys, you get a whole nother week of true crime stuff. And tonight, actually, if my mic is sounding okay, and I'm just watching everybody pile in. It's so nice to see you, Turlington and Liam and Shill. Welcome. Hey, Charlotte, Karen, Juju. Nice to see everybody. Everybody coming in, you know. Boone is always ready to give her curveballs. I'm wondering if she played softball in school. I mean, besides being a very good student, that she tells everybody. But, yeah. Hopefully the mic is okay. Could somebody just let me know that everything's clear and ready to go ahead and don't have to play with any buttons? That would be good. Well, today we're going to talk about baby reindeer, or actually not necessarily baby reindeer, a lawsuit, a civil lawsuit that was the results of the series Baby Reindeer that Netflix did. And, well, you may say that it's like kind of crazy. It was a great series and all of that, but like, why cover a lawsuit? Well, I think today you'll understand that a little bit more, what my actual obsession is with this case. Not only was I obsessed with the series itself, because it was so well done. I mean, the Emmy, like recently, all the awards that it got. I mean, I'm not alone. It touched on subjects in reality that and portrayed them in such a way that it was the closest thing to reality I've ever seen. The ugly truth about all of it, about failed human beings, all of us, and how we don't always do the right thing, and how damaged people hurt damaged people, you know, and yet still it doesn't give them the right, you know. So it was just an honest portrayal, but unfortunately for Netflix, well, not so much Richard Gere, because this was his story, and he had a play about it before, which he said based on a true story. And when he sold it to Netflix, it was under that pretense that it was actually based on a true story. But Netflix played around a little bit, and well, not realizing the lengths that Fiona Harvey would go to, no, they called a lawsuit. And that's what this civil case is about. Fiona Harvey actually stating that she's been caused great harm by Netflix's not protecting her and letting people find out who she was. And that she's under such stress because of it. And that basically the whole story is untrue. Well, we all know that, well, after many interviews and some admissions, even on the end of Fiona Harvey, she can't exactly say that anymore. But I think today we're going to have a really good example of how these civil lawsuits for damages of defamation and you did me wrong and you need to pay me millions of dollars can actually go. Because this lawsuit was filed in California. And California has anti-SLAPP laws, just like most of our states, except for Texas, where Logan Paul had the nerve to file his lawsuit against CoffeeZilla so that he couldn't actually get it tossed out of court for the ridiculousness that it is. Oh, but I digress. Anyway, about anti-SLAPP. Today, buckle up, buttercups. We're going to learn a lot about anti-SLAPP because today I have a perfect example of the weighing out of what is the pros and cons of anti-SLAPP in regards to a judge's ruling, because the judge did rule on Netflix's anti-SLAPP cross-claim that we talked about in the last time that we did True Crime and Legal Update concerning Miss Harvey. We actually have a very good example of how it gets weighed out and what are the key parts of it and how they have to balance it between the plaintiff and the defendants in the case. So, well, let's just go over first a little bit. I'm not going to give you too much of a refresher. But just in case you didn't know, what's Richard Gett? That's Fiona Harvey. And this is going to be about Baby Reindeer in the lawsuit that Netflix got. And we're going to go over some of the actual filings and all that happened since the last time we talked. So we had some docket updates. There's been a decision, or rather an order from the judge on the case on the anti-SLAPP. They also assigned a mediator. Okay, we're going to talk a little bit about mediation in California and the requirements. And then, of course, the next thing on the docket is after the order, the anti-SLAPP order, there was a notice of appeal. But I'm not going to tell you by who yet until we read the order. Well, in order to actually go over that anti-SLAPP, I do hope you like the sound of my voice, people. I will be checking in for questions here and there, but we're going to read the judge's ruling in, well, sorry, not sorry, it's 18 pages, and I'm excited about it. And by virtue, you're going to have to be with me because I'm dragging you with me. Okay, so without further ado, let me just drop this and bring up the star of tonight's actual. We're going to actually get into the particulars. And it's too big for a change. Who would have thought I'd ever say that? It is definitely too big for the screen. Yes, I was talking about the screen, people. Okay. Don't be like that. Okay. And okay, let's go back. We're going to start with this judge. Now, this is in a different format than we normally have up here for you guys. I hope you didn't mind my littleness there for a second, but that's how it's got to be sometimes. I'm actually going to do this nope, that doesn't look good either. How about I do this? You don't need to see me. You can hear me because this deserves the starring role. Okay. In Central District of California, this is a district court, and this is by the Honorable R. Gary Klausner, and I've got to say, very, very well written. It's a little bit different. It doesn't look like a brief, but this is his in chambers, which means he's there writing this thing himself. There's nobody else present, and this is his order on the anti-SLAPP. Now, I'm gonna go over what he wrote and not really go into the anti-SLAPP that was filed by the defendants, Netflix et al., all their little companies, united, because we did go over that in the last one. And basically, the premise of an anti-SLAPP is to cover it under free speech, that Fiona Harvey doesn't have a right to sue them for their creative license and free speech to say what they want because they really didn't cause her any harm, and trying to prove that substantially most of what they said was true. That's in a nutshell. And then, of course, Fiona Harvey, in several failed attempts, tried to actually motion against the anti-SLAPP by them, saying that, some of it might be true, which she had to concede to, and she actually proved in her briefs, and we talked about that last time. But there were some things that she did point out weren't. And we're going to go over all of that because this judge's ruling is pretty much the best that I've seen so far in regards to something like this. And for those of you, before you say anything, those of you that like to read along, here's a link. And I'm pretty sure I checked it, so I'm pretty sure it's going to be good for you guys. Okay, so the judge writes, and this is all the judge's voice, although my tone will depict it. Introduction to the anti-SLAPP motion and order. On June 6th of 2024, Fiona Harvey, the plaintiff, filed a complaint against Netlix Inc. and Netflix Worldwide Entertainment LLC, collectively the defendants, asserting 6 claims under California law: defamation, intentional infliction of emotional distress, negligence, gross negligence, violations of her right of publicity under California common law, and violations of her right of publicity under California Civil Code. Presently before the court are defendants' special motion to strike under California's anti-strategic lawsuit, otherwise known as anti-SLAPP, against public participation, anti-SLAPP. Statute ECF number 26, defendant's motion to dismiss under the same, and plaintiff's motion to strike under the same. For following reasons, the court denies defendant's special motion to strike and grants defendant's motion to dismiss in part and denies plaintiff's motion to strike. So this judge actually just cut to the chase. Okay, so we've got a partial grant and some denials here. Okay, but basically, before we get too much into it, this case is going forward. It didn't get tossed. An anti-SLAPP is designed to try to get the case sauce before it costs the court a lot of money. Okay, it kind of sets out the premise ahead of time to see if a case is actually even here. But this judge is now going to take us point by point why he decided the way he did. And he's going to go over the factual background. Plaintiff alleges the following facts in her complaint, i.e., Fiona Harvey. Defendants operate Netflix, an eponymous streaming media service that produces and distributes content to over 260 million paid subscribers worldwide. On April 11th of this year, defendants released a 7-episode limited television series written, produced, and starring Scottish comedian Richard Gadd, titled Baby Reindeer, the series. This series, set in 2015, follows Donnie Dunn, a struggling Scottish comedian played by and based on Gadd, trying to advance his comedy career while working as a bartender at a pub and dealing with a stalker named Martha Scott. You know, the judge either wrote him himself or he's got a pretty savvy paralegal or court clerk. Despite using fictional names for its characters, the series is heavily based on reality. In an interview with GQ magazine, Gadd stated that he disguised his real stalker as Martha in the series. As it turns out, Martha is none other than the plaintiff. There are numerous similarities between Martha and plaintiff. For instance, the series portrays Martha as a Scottish lawyer living in London, 20 years older than Donnie, accused of stalking a lawyer in a newspaper article who communicated with Donnie on social media. Likewise, plaintiff is a Scottish lawyer living in London, 20 years older than Gadd, accused of stalking a lawyer in a newspaper article who communicated with Gadd on social media. Furthermore, Martha's accent, manner of speaking, and cadence are also indistinguishable from plaintiff's. However, there are several key differences between plaintiff and Martha. In particular, the series states that Martha is twice convicted criminal that spent 5 years in prison for stalking. States that Martha stalked a police officer. Depicts Martha sexually assaulted Donnie in an alley, grabbing his genitals without consent. Depicts Martha violently attack Donnie in a pub, smashing a glass bottle over his head and gouging his eyes with her thumbs. And depicts Martha stalk Donnie by waiting outside his home every day for up to 16 hours. Despite these differences, defendants present the series to be a true story. Less than 2 minutes into the first episode, the text, "This is a true story," appears on screen. Believing the series to be true, viewers immediately got to work trying to identify the real Martha. Within days, these viewers found a public post plaintiff made on Gadd's social media profile in 2014, asking him to hang my curtains, which matched a quote from the series. Thus, the viewers concluded that plaintiff was the real Martha, and that plaintiff also was a twice convicted criminal that spent 5 years in prison for stalking, stalked a police officer, and sexually assaulted Gad in an alley, grabbing his genitals without consent. There are great footnotes if you are interested in those. Check the link. Also, that she violently attacked Gad in a pub, smashing a glass bottle over his head and gouging his eyes with her thumbs, and stalked Gad by waiting outside his home every day for up to 16 hours. None of these statements were true, however. Nonetheless, these viewers inundated plaintiff with threatening and harassing messages. This harassment became so pervasive that it caused plaintiff to suffer severe emotional distress in the form of anxiety, nightmares, panic attacks, shame, depression, nervousness, stomach pains, loss of appetite, and fear, specifically a fear of going outside. Defendant should have known that the statements and portrayals of plaintiff through Martha were false, and that viewers would discover her identity and harass her based on these false statements and portrayals. Yet defendants made no effort to investigate the accuracy of these statements and portrayals or take further measures to hide her identity. Defendant now special motion to strike. The parties submit the following facts in support of their briefings regarding defendant's special motion to strike. The plaintiff stalking. In 1997, plaintiff was hired as a trainee solicitor at a law firm, L&L Lawrence Solicitors, under Laura Ray, a Scottish solicitor, who was then married to member of British Parliament Reindeer. Ray terminated plaintiff's employment just a few weeks after hiring her. Consequently, plaintiff launched a harassment campaign against Ray and her family, sending threats, following them, and making false police reports against them. Plaintiff's harassment continued until April 29, 2002, when Ray obtained an interim interdict, which is essentially a restraining order prohibiting plaintiff from contacting her. Plaintiff's conduct got the attention of the media, leading to multiple news stories between 2000 and 2004. These news stories revealed that plaintiff had also stalked first Prime Minister of Scotland, Donald Dewar. Okay, this has all been documented. Around 2014, plaintiff met Gad, who at the time was a struggling comedian working at a pub. Plaintiff almost immediately began stalking and harassing Gad. She learned plaintiff's shift patterns so she could be at the pub while he was working, followed him around town, and attended many of his comedy and theater performances. She even got handsy with him, pinching and touching various parts of his body, including his bum, without consent. And on one occasion, she got violent with him, shoving him in the back of his neck. And for years, she sent him countless emails, social media messages, voicemails, and handwritten letters. Plaintiff's harassment continued until 2017, when Gad obtained a first instance harassment warning against her. Plaintiff was never prosecuted or convicted of a crime for her conduct. However, according to Michelle Oakley, a criminal lawyer who practices in England and Wales, plaintiff's conduct toward Ray, Dewar, and Gad rose to the level of criminal stalking, likely punishable by at least 5 years imprisonment. Around 1999, plaintiff was active in politics. She sought a nomination for a seat in the Scottish Parliament. This nomination process was private. She did not canvass or make speeches or run media advertisements seeking votes from members of the public. Though she was on 4 shortlists for 4 seats, her bid was ultimately unsuccessful. Then comes the release of the series. 2 weeks after the series aired, plaintiff identified herself as the real Martha on a Facebook and criticized Gad in the series. Not long after, plaintiff sat for an interview with Piers Morgan to reaffirm that Martha was based on her, but deny many of the statements about Martha that were falsely attributed to her. Shortly after, plaintiff filed her complaint. The Sunday Times ran an article about the lawsuit. The article suggested that defendants went out of their way to add the "this is a true story" line, stating sources in the TV industry have told the Sunday Times that that line was a request from the defendant and that Gad expressed concerns about presenting it as such. Defendants added this line even though Gad's original theater play, which the series was adapted from, stated that it was simply based on a true story. However, each episode of the series included a disclaimer after the end credits stating, "This program is based on real events. However, certain characters, names, incidents, locations, and dialogue have been fictionalized for dramatic purpose." You note I'm not reading the notations of where these is coming from. It's all coming from the previous filings, you know. Under okay, so now we're going to go to the that was all in the actual history of everything, and from the filing of the anti-slapp, all the notations are from the actual pages of it and the declarations. Okay, so plaintiff's motion to strike this part. Okay, judicial standard. This is he's going to now talk about Fiona's answer back to the anti-slapp and what points he has to discuss in it. Under Federal Rule of Civil Procedure, Rule 12, a court has discretion to strike from a pleading an insufficient defense or any redundant, immaterial, impertinent, or scandalous matter. In evaluating a motion to strike, a court must view the pleading under attack in the light most favorable to the pleader. And that means either the defendant or the plaintiff, depending on who filed the brief. The pleader. Motions to strike are disfavored, see Nelson v. Union, and are generally not granted unless it is clear that the matters to be stricken could have no possible bearing on the subject matter of the litigation. So now the discussion. Defendants bring a special motion to strike and a motion to dismiss. Defendants support their special motion to strike with declarations by Gad and Ray stating that plaintiff stalked and harassed them, as well as a declaration by Oakley opining that plaintiff could have been convicted and given the same sentence as Martha. Plaintiff moves to strike these declarations as immaterial and scandalous. However, for the reasons discussed below, these declarations are relevant and material. Accordingly, the court denies plaintiff's motion. Defendant's special motion to strike, the judicial standard, the same. Under California Code of Civil Procedures, also known as the anti-slapp statute, a defendant may file a special motion to strike a complaint that is brought primarily to chill the valid exercise of free speech and petition. Such motions may be brought in federal court against a plaintiff's state law claims. Section 425.16 provides a two-step burden-shifting framework. Here's where we're going to get our education, buttercups. First, the defendant has the burden of showing that the challenge cause of action arises from activity protected under the statute. And that comes from Blackburn versus Brady. If the defendant does not meet this threshold burden, the court must deny the motion. If the defendant meets the burden, then the plaintiff must demonstrate a probability of prevailing on the merits of the claim. To establish the requisite probability of prevailing, this plaintiff must demonstrate both that the claim is legally sufficient and that there is sufficient evidence to establish a prima facie case with respect to the claim. The court evaluates the evidence using a summary judgment-like procedure, considering only whether the evidence, if credited, would support the claims. If the plaintiff is unable to satisfy its burden, the court should grant the defendant's motion and strike the complaint. Because the statutory intent is to provide a quick, inexpensive method of dismissing these sorts of lawsuits, leave to amend is improper. So the discussion starts. Plaintiff asserts claims for defamation, the IIED, negligence, gross negligence, violations of her right of publicity under California common law, and violations of her right of publicity under California Civil Code. Defendants moved to strike the complaint in its entirety, arguing that the claims fall under anti-SLAPP. The court evaluates each step of the anti-SLAPP framework in return. So we go with number one, protected activity. Protected activity, free speech. Under the first step of the anti-SLAPP framework, the defendant bears the burden of showing that the challenged cause of action arises from an activity protected by the statute. This section 42516 protects the constitutional right of free speech in connection with a public issue or an issue of public interest. Speech in connection with a public issue or public interest generally concerns a person or entity in the public eye, conduct that could directly affect a large number of people beyond the direct participants, or a topic of widespread public interest. Courts employ a two-part analysis to determine if speech is connected with a public issue. First, the court determines what issue the speech implicates based on the content of the speech. Second, the court determines whether there is a functional relationship between the speech and the public conversation about the issue based on context. The first step will virtually always be satisfied, as defendants can easily succeed in drawing a line, however tenuous, connecting their speech to an abstract issue of public interest. The second step is usually more important, as it is not enough that the statement refer to a subject of widespread public interest. The statement must, in some manner itself, contribute to the public debate. Here, plaintiffs' claims arise from the series. Defendants argue that the series is protected speech because it concerns sexual abuse, harassment, and stalking. The court agrees. The series discusses issues of sexual abuse, harassment, and stalking, which are all well-established topics of widespread public interest. The series contributes to the public debate surrounding these issues by highlighting them and showing how victims are impacted by them. Thus, the series itself satisfies both steps and constitutes protective speech under anti-SLAPP. That was easy. Having found the defendants met their burden of showing that the series and statements are protected speech, the court proceeds to the second step of the anti-SLAPP framework. So I ask you before we go on, those of you in the chat and those of you listening later, is not this well written as just a step-by-step? How do we look at this? I can't applaud this judge more. He's giving us a framework on how they decide these things, as well as telling us in this particular case how he come to the conclusion that he had, step by step. I'm reading some of the comments and they're making me laugh, so I'm not going to put them up yet. But yes, Deep State Annex, I do believe that SLAPP suits are the worst. They're frivolous and just meant to cause people pain. They are most civil lawsuits for defamation can actually go through this process of anti-SLAPP, and some of them just get tossed. Absolutely, because it is a good framework for going through what could be frivolous, and it is meant to save the court a lot of time. Okay. All right. So now part two. Under the second step of the anti-SLAPP framework, plaintiff bears the burden of demonstrating a probability of prevailing on the merits of her claim. And so the court addresses each claim in turn. So therefore, the first part was that since they filed the anti-SLAPP, defendants are saying, oh no, let me show you why this is protected under free speech and why this can't be. And then plaintiff gets to come back and say, well, maybe so, but I can prove my claims on why you shouldn't be allowed to file that. And let's just see where that goes. So under the first part, defamation, the court is going to actually address the probability of prevailing on the merits. Okay. So under the first part, for the plaintiff claiming defamation. To prevail on a defamation claim, a plaintiff must identify a publication that is false, defamatory, unprivileged, and has a natural tendency to injure or cause special damage. The defamatory statement must specifically refer to or be of and concerning the plaintiff. Plaintiff asserts a claim for defamation, alleging the defendants used Martha to make false statements about her. Specifically, plaintiff alleges that defendants falsely stated that plaintiff was twice convicted criminal that spent 5 years in prison for stalking, stalked a police officer, sexually assaulted Gad in an alley, grabbing his genitals without consent, violently attacked Gad in a pub, smashing a glass bottle over his head and gouging his eyes with her thumbs, and stalked Gad by waiting outside his home every day for 16 hours. Plaintiff argues that her claim has a probability of succeeding on the merits because the above statements are false, defamatory, unprivileged, harmed plaintiff's reputation, and caused her emotional distress. Defendants disagree, arguing that the claim fails because the statements are not about plaintiff. The statements are not assertions of fact. The statements are substantially true. Plaintiff is libel proof. And the statements are legally protected opinion. And plaintiff is a public figure and cannot establish actual malice. The court addresses each argument in turn. I love the way he's writing this. He is making sure that even the rabbit stalker with the thirst for fame understands this decision. Yes, he is. Yes, he is. And I think we're all going to be surprised at the end, actually. Statements about the plaintiff. So he's going to address each argument in turn. So here we go through the statements, okay? Let me just grab a little drink. Quick. Defendants argue that a reasonable, to be defamatory, we'll start at the beginning. A statement must be reasonably interpreted as an assertion of fact about an individual. In actions based on the identification of a fictional character with the actual plaintiff, the test is whether a reasonable person would understand that the fictional character therein pictured was, in actual fact, the plaintiff, acting as described. Whether defamatory statements can reasonably be interpreted as referring to plaintiffs is a question of law for the court. Defendants argue that a reasonable person would not understand that Martha is, in actual fact, plaintiff, such that any statements about Martha would be about plaintiff. In particular, defendants argue that the similarities between Martha and the plaintiff are so broad that a reasonable person would not have been able to identify her. The court disagrees. This is not the typical case where a plaintiff happens to be one of hundreds of people that match a fictional character's broad characteristics. Rejecting defamation claim because the plaintiff's similarities to a fictional character of the same were broadly applicable to many people was actually referred to in Tamkin in 193 of California as a public applicable 4th and 147th case, Polydorus versus 20th Century Fox Film Corporation. Rather, Martha and plaintiff has specific similarities that few others could claim to share. Specifically, Martha and plaintiff are both Scottish lawyers living in London. They're both 20 years older than Donnie or Gad. They're both accused of stalking a lawyer in a newspaper article. They both communicated with Donnie Gad on social media. While there may be numerous Scottish lawyers living in London of the same approximate age as plaintiff, it is very likely that only plaintiff has been accused of stalking a lawyer in a newspaper article while also communicating with Gad on social media. Nonetheless, defendants argue that even if the similarities were strong and specific, a reasonable person would not have identified plaintiff because it required research and cyber sleuthing. And these cyber sleuths are not representative of reasonable persons. I'm going to say that again because I particularly love that line. These cyber sleuths of the internet, you fanatical people that put your noses where they don't belong, are not representative of reasonable persons. However, plaintiff alleges that it required little effort for these cyber sleuths to find her, as they simply found her public post on GAD's social media, referencing the same hang my curtains joke referred to in the series. Defendants do not offer any evidence to the contrary or provide any convincing argument as to why this effort would be unreasonable, particularly given Gad's statement confirming that Martha was based on a real stalker, which could arguably be viewed as an invitation to go find plaintiff. Thus, this argument fails. Having established that a reasonable person could understand the statements about Martha to be about plaintiff, for clarity and brevity, the court refers to the statements as statements about plaintiff from this point forward. In other words, he's saying that argument fails. Martha is Fiona, and from now on, we're just calling her plaintiff. That's the judge's standpoint. So, assertion of facts. Whether a statement may be preserved as a factual assertion depends on the totality of the circumstances in which it was made. Court considers three factors: the statement in its broad context, which includes the general tenor of the entire work, the subject of the statements, the setting, and the format of the work. 2, the specific context and content of the statements, analyzing the extent of figurative or hyperbolic language used and the reasonable expectations of the audience in that particular situation. And then 3, whether the statement itself is sufficiently factual to be susceptible of being proved true or false. As to the second factor, dramatic devices may demonstrate that a statement is not an assertion of fact. For instance, in the court case Kordolkovskaya versus Gay, the DC Circuit, drawing upon California law, found that a theatrical play based on a historical fiction did not contain assertions of fact because it used dramatic, borderline fantastical elements. For instance, the play included a comical depiction of Russian leader Vladimir Putin, often accompanied by a larger-than-life-sized stuffed tiger, who on multiple occasions recites an absurdist poem about voluptuous tarts. The play also included a ghost. The court found that these fantastical devices confirmed to any reasonable viewer that the play is fictional and did not convey historical facts. Defendants argue that a reasonable person would not understand the statements about plaintiff to be assertions of fact. Specifically, defendants argue that a reasonable person would understand from context that the alleged statements are not factual because the series uses dramatic cinematic cinematic elements like tonally dissonant soundtracks, literal tunnel vision, time lapses, and montages. The court disagrees. Each of the factors suggests that the statements would be interpreted as assertions of fact. First, while the statements were made in a series that largely has the trappings of a black comedy drama, the very first episode states unequivocally that this is a true story, thereby inviting the audience to accept the statements as fact. Second, while the series uses some dramatic cinematic elements, these elements are not so absurd or so real as to neutralize the audience's expectations that they are watching a true story. Indeed, these dramatic devices are far tamer than the fantastical use of stuffed tigers, absurdist poetry, and ghosts in Kordolkovskaya. Third, the statements are sufficiently factual to be susceptible of being proved true or false. Whether the plaintiff was convicted, stalked a police officer, sexually assaulted Gad, violently attacked him, or waited outside his home are all provable assertions. Under the totality of the circumstances, a reasonable person could interpret the statements to be assertions of fact. Thus, this argument fails. Substantial truth is a defense of defamation. Under this defense, if the substance, gist, or sting of the alleged defamatory statements are true, the defendant cannot be held liable for any slight inaccuracies in details. That comes from Mason versus New York Magazine. In other words, the statement is not considered false unless it would have a different effect on the mind of the reader from that which the pleaded truth would have produced. Defendants argue that plaintiff's claims fails because the statements about plaintiff are substantially true. Specifically, defendants offer evidence demonstrating, although plaintiff is not a twice convicted criminal that spent 5 years in prison for stalking, she could have been convicted and sentenced to 5 years in prison for stalking Ray or DeWar and Gad. Although plaintiff did not stalk a police officer, she did previously stalk Ray, an attorney, her husband, a member of British Parliament, and DeWar, the First Minister of Scotland. Although plaintiff did not sexually assault Gad in an alley, grabbing his genitals without consent, she did get handsy with him, pinching and touching various parts of his body, including his bum, without consent. Although plaintiff did not smash a glass bottle over Gad's head and gouge his eyes with her thumbs, she did shove him in the back of the neck. And although plaintiff did not wait outside Gad's home every day for up to 16 hours, she did follow him to the pub and his comedy and theater performances. However, even assuming this evidence to be true, the court disagrees that defendant's statements would be substantially true. For instance, there is a major difference between stalking and being convicted of stalking in a court of law. Likewise, there are major differences between inappropriate touching and sexual assault, as well as between shoving and gouging another's eyes. While plaintiff purported actions are reprehensible, defendant's statements are of a worse degree and could produce a different effect on the mind of the viewer. Thus, this argument also fails. Now we're going to see if he agrees that they're libel proof. So far, the judge has said, I don't agree that it's not defamation because the statements are true, because reasonable people are going to believe it, because you made reasonable people believe it. And yes, you are exaggerating the story and making it better, but the substantial part of it that's true leads everybody to believe all of it is. And we've already agreed, Martha's Fiona. So now we're going to see if he agrees that Netlix is libel proof. Yes, they can fall under dramatization, but dramatization doesn't always protect you from defamation claims, as we are reading here. There is a two-part test, and so far they failed the first part. Let's see if they get through the second part. Under the libel proof doctrine, a plaintiff's reputation with respect to a specific subject may be so badly tarnished that he cannot be further injured by allegedly false statements on that subject. In such a scenario, rather than allow the case to proceed for nominal damages, courts will dismiss the claim outright. Whether a plaintiff is libel proof based on past conduct depends upon the nature of the conduct, the nature of offenses, and the degree and range of publicity received. The libel proof plaintiff doctrine is to be sparingly applied, as it is unlikely that many plaintiffs will have such a tarnished reputation that their reputations cannot sustain further damage. I don't know. I could use Logan Paul as an example for this one. And even where application of the doctrine is appropriate, it must be cabined to statements on the same subject to which the plaintiff's reputation was tarnished. As then Circuit Judge Scalia explained, it is shameful that Benedict Arnold was a traitor, but he was not a shoplifter to boot, and one should not have been able to make that charge while knowing its falsity with impunity. Defendants argue that plaintiff's claim fails because she is libel-proof. Specifically, defendants argue that plaintiff's reputation has been badly tarnished by the public accusations that she stalked Ray. However, the court disagrees. As a threshold matter, it does not appear that any California court has recognized the libel-proof doctrine. Defendants do not cite any published California Courts of Appeal or California Supreme Court authority recognizing the doctrine, nor is the court aware of any such authority. On this basis alone, the court may reject this argument. However, even if there were such an authority, the doctrine would not apply. Though plaintiff's publicly reported stalking inevitably tarnished her reputation, it was reported only a handful of times over 20 years ago. It is difficult to imagine that such scant publicity would render plaintiff's reputation so badly tarnished that she could not be defamed 20 years later. And even if plaintiff could be considered libel-proof on the subject of stalking, it seems unlikely that this would apply to false statements of sexual assault and physical violence, in much the same way that Benedict Arnold's reputation as a traitor would not excuse false accusations of shoplifting. Thus, this argument also fails. Legally protected opinion. Even if all the elements of defamation are satisfied, a defamation claim may nonetheless fail if it is barred by the First Amendment. New York Times versus Sullivan. Libel can claim no talismanic immunity from constitutional limitations. It must be measured by standards that satisfy the First Amendment. One restriction imposed by the First Amendment applies to legally protected opinion. When an author writing about a controversial occurrence fairly describes the general events involved and offers his personal perspective about some of its ambiguities and disputed facts, his statements should generally be protected by the First Amendment. Defendants argue that the statements are legally protected opinion under the First Amendment. Specifically, defendants argue that the series is clearly written from Gad's perspective and states Gad's opinion. The court disagrees. It is not clear that the series states only Gad's opinion. If anything, the series appears to present itself as fact, not opinion, by stating that it is a true story. Thus, this argument fails. Public figure and actual malice. Another restriction imposed by the First Amendment applies to public figures. Public figures may only bring claims for defamation if they can show that the defamatory statement was made with actual malice. Defendants argue that plaintiff qualifies as a public figure and thus must demonstrate actual malice. The court first considers whether plaintiff qualifies as a public figure. And so this will be a good exercise in this one. A, public figure. There are two types of public figures. An all-purpose public figure is someone who has achieved such pervasive fame or notoriety that it becomes a public figure for all purposes and in all contexts. A limited purpose public figure is someone who voluntarily injects himself or is drawn into a particular public controversy and thereby becomes a public figure for a limited range of issues. Whereas an all-purpose public figure must prove actual malice for all defamation claims against him, a limited-purpose public figure must prove actual malice only for defamation claims related to the public controversy he is associated with. Defendants argue that the plaintiff is either an all-purpose public figure because of her run for office or a limited-purpose public figure on issues related to stalking, harassment, and assault because of her publicly reported stalking of Ray and DeWar. Plaintiff disagrees, arguing that she does not qualify as an all-purpose public figure because her run for office was largely private, and that she does not qualify as a limited-purpose public figure because her stalking was last publicized more than 20 years ago. and was not made public through any voluntary act. The court agrees with defendants that plaintiff may qualify as a public figure. First, plaintiff offers no authority suggesting that the functional aspects of her political candidacy would disqualify her from being an all-purpose public figure. Plaintiff does not cite any case law suggesting that a candidate seeking a private nomination would not qualify as a political candidate and public figure. Second, plaintiff offers no binding authority suggesting that the length of time since her stalking was publicized or her lack of voluntary act in getting publicized would disqualify her from being a limited purpose public figure. Courts have consistently held that a passage of time does not alter an individual's status as a limited purpose public figure. Plaintiff's only case to the contrary, Briscoe versus Reader's Digest, is inopposite and outdated, and it concerned an invasion of privacy for truthful disclosure of past crimes, not defamation, and was later overruled. And while plaintiff argues that her stalking was not made public through any voluntary act, the case law makes clear that a person can become a public figure if he voluntarily injects himself or is drawn into a particular public controversy. Though plaintiff might not have voluntarily injected herself into controversy, she was undoubtedly drawn into it. Having found that plaintiff may qualify as a public figure, the court next addresses actual malice. If plaintiff qualifies as a public figure, we must demonstrate that the defamatory statement was made with actual malice, meaning knowledge that it was false or with reckless disregard, or whether it was false or not, or of whether it was false or not. At trial, actual malice must be proved by clear and convincing evidence. To survive a special motion to strike under anti-SLAPP, which requires a plaintiff to show a probability of prevailing, a public figure plaintiff must show a probability of proving actual malice by clear and convincing evidence. Defendants argue that plaintiff cannot show actual malice, but the court disagrees. The series was adapted from Gadd's theater play, which stated that it was based on a true story. This disclaimer put defendants on notice that certain details were likely false. Yet, according to the Sunday Times, defendants insisted on adding "this is a true storyline" to the series despite Gadd's concerns. This suggests a reckless disregard of whether statements in the series were false and thus actual malice. Thus, this argument fails. Because each of defendants' attempts to defeat the defamation claim fail, plaintiff has demonstrated that the claim has a probability of prevailing on the merits. Accordingly, the court denies defendants' special motion to strike as to the defamation claim. So, in other words, if we go through that whole lesson that this wonderful judge has laid out for us, in using all of the factors of defamation for the first claim, it's going to be up to the jury to decide if she was defamed and the evidence that gets presented. Because for the reasons to be struck out, that they were substantially true, well, they did exaggerate them, and they admit they did. And the parts that they exaggerated aren't true. And she's saying she suffered for that. And it's evident that they did take some creative license. Nobody's arguing that. And that one statement that Netlix made in the beginning of the series is the linchpin of this whole case. Had they just left the words "based" there, as Richard Gadd intended when he wrote, when he performed it in the theater, when he talked about it in his comedy shows, there would not be an issue here. But they took that word out and made it a whole different thing. So now we're going to go on to the rest of plaintiff Fiona Harvey's claims to see which or if any of those will get tossed. Defendants argue that plaintiff's remaining claims for the IIED, negligence, gross negligence, and right of publicity should be stricken if her defamation claim is stricken, as they are similarly premised on the series. As discussed above, however, we're not dismissing the defamation claim. It survives the defendant's special motion to strike. Therefore, this argument fails. The defendant do not raise any other arguments with respect to these claims. Thus, for the court denies defendant's special motion to strike all of the other remaining claims. Accordingly, the court denies defendant's special motion to strike in its entirety. So now they were going to strike everything, and they also filed a motion to dismiss, and he actually is addressing that here too. And we're going to go over his reasonings for that. So far, he is allowing the defamation, neglect, damages, all of that to go forward to a court. He says it's up to the court to decide now based on the evidence, because it did not pass the two-part test of substantially true and libel proof, the arguments brought forward. All right. So defendant's motion to dismiss is going to be determined this way. Under the judicial standard, under Rule 8A, a complaint must contain a short and plain statement of the claim showing that the plaintiff is entitled to relief. If a complaint fails to adequately state the claim for relief, the defendant may move to dismiss the claim under Rule 12b-6, to dismiss for failure to state a claim upon which relief can be granted. To survive a motion to dismiss, a complaint must contain sufficient factual matter, accepted as true, to state a claim to relief that is plausible on its face. A claim is facially plausible if the plaintiff alleges enough facts to allow the court to draw a reasonable inference that the defendant is liable. A plaintiff need not provide detailed factual allegations, but must provide more than mere legal conclusions. However, threadbare recitals of the elements of a cause of action supported by mere conclusionary statements do not suffice. That sounded like a warning to me. When ruling on 12b-6 motion, the court must accept the allegations in the complaint as true and construe them in the light most favorable to the non-moving party. Factual allegations must be enough to raise a right to relief above the speculative level. Dismissal is appropriate only where the complaint lacks a cognizable legal theory or sufficient facts to support a cognizable legal theory. So the discussion. Defendants argue that plaintiff's claims, as well as her request for punitive damages, should be dismissed under Rule 12b-6 because they are inadequately pled. The court addresses each in return. Defamation. Plaintiff asserts a claim for defamation. Defendants move to dismiss this claim, making the same arguments through their special motion to strike. However, as explained above in the second step of the anti-SLAPP framework, plaintiff's defamation claim has a probability of prevailing on the merits, meaning that it's both legally sufficient and supported by some evidence. Therefore, plaintiff's defamation claim is well pled. Thus, the court denies defendant's motion to dismiss as to the defamation claim. To plead IIED, a plaintiff must allege that the defendant is engaged in extreme and outrageous conduct with the intentions of causing or reckless disregard for the probability of causing emotional distress, severe or extreme emotional distress and causation. From Hughes v. Pear. A defendant's conduct is outrageous when it is so extreme as to exceed all bounds of that usually tolerated in a civilized community. And the defendant's conduct must be intended to inflict injury or engaged in with the realization that injury will result. Plaintiff asserts a claim for an intentionally inflicted emotional distress, alleging that defendants allegedly defamatory statements were extreme and outrageous and caused her severe and extreme emotional defense. Defendants argue that this claim fails because no reasonable viewer would understand the statements about Martha to be about plaintiff. The statements were not so damaging as to be extreme and outrageous. To the extent that plaintiff alleges defendants failed to investigate the accuracy of the statements, that failure is not extreme and outrageous. Plaintiff's own conduct is the cause of her emotional distress because she identified herself as the real Martha. And plaintiff has not suffered any actual emotional distress, as her allegation that she is afraid to go outside is contradicted by her decision to sit for an interview. Defendant missed the mark. First, as explained above, it appears that a reasonable viewer would understand the statements about Martha to be about plaintiff. Second, the statements may be extreme and outrageous. The series states that the plaintiff is a convicted criminal who sexually and violently assaulted Kath. These statements may rise to the level of extreme and outrageous conduct. False accusations of sexual harassment can satisfy the first element of an intentionally inflicted emotional damage claim. Third, defendants cite no convincing authority suggesting that their failure to investigate the accuracy of the statements would not be extreme and outrageous. While defendants' case found that failures to investigate insurance claims and workplace claims were not extreme and outrageous, they do not state that all failures to investigate are per se not extreme and outrageous. Fourth, plaintiff alleges that she was identified and suffered harm before she made public statements identifying herself as Martha. To the extent that plaintiff's statements afterwards might have led to more harm, defendants offer no authority suggesting that her contributing conduct would outright bar her claim. And fifth, while plaintiff's decision to sit for an interview arguably contradicts her allegation that she is afraid to go outside, she also alleges that she has suffered anxiety, nightmares, panic attacks, shame, depression, nervousness, stomach pains, and loss of appetite. Defendants offer no argument that these allegations are implausible or not credible. Thus, the court denies defendant's motion to dismiss the intentional infliction of emotional damage claim. Negligence and gross negligence. To plead negligence, a plaintiff must allege a legal duty, breach of that duty, causation, and damages. From Merrill v. Navagar, to plead gross negligence, a plaintiff must allege an act of negligence so extreme that it demonstrates want of even scant care or an extreme departure from the ordinary standard of conduct. Gross negligence is not a distinct cause of action. Rather, it is simply a degree of negligence. Plaintiff asserts claims for negligence and gross negligence, alleging that defendants breached duties to accurately represent her, investigate the accuracy of the statements about her, and take measures to prevent viewers from identifying her. Defendants argue that these claims fail because they are largely duplicative of her defamation claim, and the court agrees with the defendants. Plaintiff's allegations with respect to duty largely mirror her defamation claim. In this manner, plaintiff essentially alleges that defendants owed a duty to not defame her. However, plaintiff offers no authority suggesting that she can bring a defamation claim and a negligence claim premised on that defamation claim. Indeed, multiple courts have rejected such negligence claims as duplicative. And they cite the case laws. To be sure, plaintiff identifies a lone Ninth Circuit case suggesting that a defamation claim may also support a negligence claim. She uses Winter v. G.P. Putnam Sons. In Winter, the Ninth Circuit rejected a negligence claim premised on a publisher's duty to investigate the accuracy of negligent false statements. But in a footnote, the court stated, a stronger argument might be made by a plaintiff alleging libel or fraudulent, intentional, or malicious misrepresentation, but such is not contended in this case. This footnote is of little weight. First, the Ninth Circuit did not state that such a claim would be viable. It simply stated that such a claim might be stronger than one that clearly failed. Second, the footnote is plainly dicta. The Ninth Court declines to allow otherwise clearly duplicative claims to proceed based on such scant authority. Moreover, even if plaintiff's negligence claim were not duplicative, her gross negligence claim would still fail because it is not a distinct cause of action. Thus, the court grants defendant's motion to dismiss as to the negligence and gross negligence claims. Right of publicity. To plead a violation of the California common law right of publicity, a plaintiff must allege that the defendant used his identity, the appropriation of his identity was to defendant's advantage, commercially or otherwise, that they did not consent, and they were injured as a result. This is from Laws versus Sony Music Entertainment. See also Downing versus Abercrombie and Fitch. To plead a violation of the right of publicity under California Civil Code 3344, a plaintiff must allege the defendant knowingly used his name, voice, or signature, photograph, or likeness for purposes of advertising without their consent. The right of publicity does not allow an individual to censor all portrayals of him. Winter versus DC Comics. Rather, it gives him the right to prevent others from misappropriating the economic value generated by his fame. Plaintiff asserts a claim for violation of her right of publicity under California common law. Defendant argues that this claim fails because plaintiff does not allege that defendants used her identity to their advantage or for advertising. The court agrees with defendants. Plaintiff does not allege that she is famous such that defendants would stand to gain by using her identity. Thus, she fails to adequately allege a right to publicity claim either under California common law or California Civil Code. Thus, the court grants defendant's motion to dismiss as to the right of publicity claims. And punitive damages. Punitive damage may be imposed where a defendant is guilty of oppression, fraud, or malice. Plaintiff includes a prayer for punitive damages in her complaint, asserting that defendants acted with oppression, fraud, and malice. Defendants argue that this prayer fails because plaintiff does not provide any factual allegations to support her assertion. Plaintiff does not dispute this. Instead, plaintiff argues that defendant's motion is improper because, according to her, Rule 12b-6 only allows a party to dismiss claims, not prayers for relief. Plaintiff misses the mark. As this court recently explained, Rule 12b-6 is the proper medium for challenging the sufficiency of factual allegations, underlining a prayer for punitive damages. That comes from Gomez versus the County of Los Angeles. And then quoting from Kelly versus the Corrections Corp of America, having failed to identify any factual allegations showing oppression, fraud, or malice, plaintiff's prayer for punitive damages fails. Thus, the court grants defendant's motion to dismiss as to plaintiff's request for punitive damages. For the foregoing reasons, the court denies plaintiff's motion to strike, meaning the case is going forward. Denies defendant's special motion to strike, case is going forward, and grants defendant's motion to dismiss in part. Specifically, the court dismisses plaintiff's negligence, gross negligence, common law right to publicity, and California Civil Code right of publicity claims, as well as her prayer for punitive damages. Plaintiff's defamation and intentional infliction of emotional damage, those claims survive. It is so ordered. Yep, and go back to here. Okay. Hello, Paula. It's nice to see you. Hello, Mousy. See, okay. Let's see. No matter how much I think that Fiona isn't a nice person and likely needs help from adequately trained individuals, I also think that Netflix done fucked up. Well, as I see, Just that one word could have saved them a world of trouble, because based on what we just learned with this judge, I mean, come on, that judge just laid it out for us point by point. It was lovely. I mean, to a nerd like me who just loves to read this stuff, I mean, I hope I didn't bore you too much, everyone, but that was an education in the step-by-step process that we deal with a lot of these civil cases for defamation. And there was definitely a good look at how a judge goes through it step by step. And I love the way he laid it out. But I agree with Liam in his statement that Netflix may have messed up a little bit here. Not Richard Gere, because I would like to make very clear, Richard Gere is not online here at all. He is not named in the lawsuit, although he is supporting Netflix and giving affidavits in, is part of the suit as far as evidence, and will be a witness. He will definitely be a witness. But his money's not on the line here at all. You know, he sold it as a based on a true story, his interpretation of what happened in his life, and he has every right to do that. Netflix on their own took the wording out, and Netflix writers enhanced with GAD some of the parts. Creative license, nothing wrong there. Taking out the part that said based on a true story may be the linchpin to this whole thing. But there are problems. Now, when Fiona Harvey first filed, this was a $170 million lawsuit. It isn't anymore. There were 3 parts that were $50 million each. 2 of them survived. And punitive damages was listed as $20 million. That did not. So we're down to $100 million. This ruling saved Netflix $70 million. But still put them on the hook, possibly, based on a trial, for $100 million. Because defamation can still be proved, or will be at least presented to a jury. And intentional infliction of emotional damage. Now, that's going to be a linchpin, because as he said, they actually have to prove that, well, the actual damage does exist. And, well, that gets contrary, because, like, well, here's where I have to inflict on some of the other coverage that's been going on. Fiona Harvey was very, very active on Facebook and very, very vocal about this series, even though she claimed never to have watched it. And did go and do the interview with Piers Morgan. And then since then has not shut up. Nope. And I listed 2 YouTube channels that actually post more on that end of it a lot. It's Gary 828, I believe, or 868 down there. You know, Simply Said. And they're having a good time posting on the antics of this case. Something I don't want to go into tonight, but you could check it out there. There's also some good videos on how the presentation of Baby Reindeer as a series, well, benefited us all in the real depiction of a very difficult subject to address, and how no one was actually the hero in any of it, showing real portrayals of the issues, and starting dialogue with all of us that needs to continue. Actually, it was a good service. There's also some videos on who's the real victim here, and they're done by therapists and psychologists and body behaviorists and all of that. Check them out. There's also some law there about the punitive damages law. There's a link there to the punitive damages and how that gets settled in California court, and also about anti-SLAPP. So you could check both of those out. There's also a link to all the free documents for this case for those of you who may be like me and want to actually just dive into this judge's actual glorious mapping of the legal system in California for us, because defamation cases are confusing. And the first step in some states is anti-SLAPP, and they can be pretty hard to decimate. I know just reading this particular order by this particular judge actually helped me understand what's going on in several other cases that I am covering, including Logan Paul v. CoffeeZilla and Marilyn Manson's anti-SLAPP that got gutted. Several in Scientology that got gutted. But now I see why. Now I see more because this judge actually laid it out step by step. And instead of just listing a case law, he actually put it in such a format that step by step you saw why he was weighing in this way or that way, point for point. It was quite enjoyable, you know. So, what? Policies. Fiona has the ability to play with one's heartstrings. I'm quite torn. She's that gal that nobody wants to be around, deservedly. She is. And I have to agree with him. Her reputation is quite horrible, especially on Facebook. I mean, she thinks she has fans. Well, they're not her friends. Like these people, they see her for what she is. Nobody wants to be around Fiona Harvey because she's a problem. She has a reputation all these 20 years, not about Richard Gere, not about Laura Ray, just her neighbors and everybody she's involved with. And when they say she's a practicing lawyer, she's not. She has a lawyer's degree and she can call herself a lawyer. But she's never been certified to practice law because she never finished her internship because she couldn't stay in her practice long enough to do it. Fiona's not a people person. She's a people person as to like the kind of person that comes into the room and everybody just watches what they do, but nobody wants to associate with them. The entertainment. It's like the circus came to town. Seriously. I mean, you know, harm Fiona Harvey, but let's be real. Like, your reputation is not so great. I mean, that's kind of why I don't want to cover the rumor part of it. And some of it's facts. I mean, the two YouTube accounts I put there, they're documenting everything that happens. It is factual. It's right from her own words, her own actions, just in her interactions in social media. Okay. I still have more though, and then we'll wrap up. But hopefully, you know, I didn't put you all to sleep because thank you for indulging me because that's one of my favorite things to do is to just read the gloriousness of the legal system when it's done right. And I have to say, that man did it right. That man did it right. All right, let me just get this ready. We have more because more happened in the case. And let's just get to that right now. Okay, I'll add this up here. A mediator was assigned. I think I put that when we first brought this up. On the docket on October 1st, a mediator got assigned. Her name is Gail Midgall Title. Because in the state of California, in these kind of suits, to prevent over expense of the legal system, which this is a good idea. It is a voluntary program, but judges themselves, based on what the type of civil claim it is, can actually order them into some type of trial to see if mediation can actually occur. And this judge actually set this for mediation, assigned a mediator. Okay. And where is this? Okay. I think this is the one. Here it is. I've got you some information on how California does that. Like if you want to go in deeper, I'm just going to give you the basics. Basically, they'll assign a mediator. Both parties will then have 30 days after the assigning of a mediator, which means we have until the end of this month to agree on a schedule for mediation, when they're going to meet, you know, what they're going to talk about, things like that. They've got to start the process within 30 days. And then the process of, you know, hashing out their issues, not in the court system, but privately with a mediator, to try to come to some kind of agreement or settlement. This would be Netflix's opportunity to actually put a cork in Fiona Harvey and just settle her with some money. It could also be an opportunity for Fiona Harvey to decide, well, I can't prove all of it, and maybe I'll just settle for a little bit less, and I'll stop because they definitely did wrong by me. It's a negotiation process. A mediator could stand there in the middle and say, listen, like, this is the fact. Like, it could go this way, it could go that way. Like, but compromise is the issue here because the court doesn't want to deal with your nonsense. And it's not fair for the citizens of California to have to pay dollar for your grievances if they can be settled out of court. So it's a way to force them to come to terms with some issues. It's a voluntary process, but some courts, like this court, actually insist that they at least attempt. Okay. One meeting, two meetings, they have to at least try. Nobody says they have to mediate out of court totally, but they have to at least have the negotiations and give this mediator at least 1 to 2 visits to try to do something with the whole case. I think it's a good way to keep frivolous or these kinds of lawsuits where someone is actually feels they were wrong and somebody else is going to have to pay money for it. That's the kind of case it is. It's a civil lawsuit. It's not criminal. Nothing that Netflix did was illegal. But did they cause somebody harm? Yeah. And in the United States, you cause somebody harm, you can make them pay for it. And that's what's going on here. So I'll give you a little bit of legal law on that. And let's hope that they do that. They've got 30 days to agree on the schedule, and then it has to be completed 45 days rather, prior to the last scheduled pre-trial conference. In other words, right before they go to trial. All right. So to wrap up, what happens next in the baby reindeer case? Well, of course, Netflix is not happy that two of those claims went forward. And since the judge used language, which I'm sure you all picked up on, like you didn't legally set a precedent here, or actually pleaded sufficiently or prove this issue of it. So therefore, I'm not dismissing it. It gives them another shot. Anyway, they put in an appeal. The appeal is going to be automatically. They put in the application for the appeal. There is no document to read for you there. They just attach the judge's decision. They filled out the application. They put it in for appeal. They will get the chance after it, whether if it gets accepted, then they plead the argument. Okay, but they don't plead the argument before it gets accepted. Then we're also going to be looking for a report on the mediation progress that could hit the actual docket any day. And also, Fiona Harvey does have the opportunity to also appeal the anti-SLAPP order on her end. I mean, she could just come up. There was several times where it got tossed because she didn't do an adequate pleading and maybe take a second shot. Now, that's not Fiona's personal problem. That's her lawyer. If you don't cite the right case and the judge points it out that, yeah, this case said something in a footnote, but that's not what it says. I mean, I think you could get a second shot at it and try to do a little bit better, And then basically we have until April 21st of 2025, which is the last scheduled pretrial conference before this goes to trial on May 6th of 2025. They have until that April 21st date to finish the mediation process and get all of this knocked out as regards to witnesses and all of that. You may remember that Fiona Harvey fought really hard to get the declarations of Richard Gadd, Miss Oakley, and Laura Ray tossed out as not relevant. She's literally suing them for being claimed for going to jail for stalking, but nobody's allowed to talk about the unjailed stalking that she did. The argument didn't make any sense, and that got tabled pretty quick. And I do believe we covered that prior in a previous episode of True Crime and Legal Update where we went over this case. There is a playlist just for this case below. This will be the third episode in it. We've got some time, but this one's actually going through the courts pretty quickly. Since it just got filed this year and having a trial within a year and getting it all sewed up, let's see if it actually makes it to trial on May 6th. With any luck, Netflix will take it on the chin and Richard Gadd can actually move on from this situation, a little bit because, I don't like Fiona Harvey. I think she's a dangerous individual. How she's getting away with what she gets away based on the fact that everybody just feels bad because she may have a mental health issue or she needs the help she needs. She's a bully. She's a social media bully. She's abusive. If you go and check out her social media profile and presence, she's the worst of the cyber stalking crew, which is what gives her such internal knowledge on how they all did this and found her, because she that woman. Okay, she is. And there's no hiding it. There's no hiding it that her reputation is not good. But it's not good based on the 20 years ago. It's just not good based on her social media presence now, which is not what was being portrayed by Netflix, nor what Netflix argued in their anti-slap. Had they brought out her current status on social media, they might have had a better shot, but I'm no lawyer. I don't even know if that's possible, actually. But it just occurred to me as I was reading it, if they had actually gone deeper into what she's been doing while they were making this actual series and after it came out, they might have had a better case, because she actually does come off as an aggressive person causing harm to others. And I might even get sued for just saying that. So let's just say allegedly, my interpretation, in my own opinion, of the tweets and the things that are not tweets, but the Facebook posts that I have seen and the actual emails that I have read, and all of this in her tone and how she gossips, attacks, and is just mean. And actually, several actual published incidences of her actually going to these actual official organization meetings and attacking members of the council and stuff like that, saying actually very racist, bigoted things, very things about people's private lives in public speaking forums of this nature. Like when I say the reputation is not good, I mean, allegedly, I'm saying in my humble opinion, like from what I saw, there's enough evidence there to prove that. But anyway, I digress. Well, let me just check for some questions. You guys have been so patient while I read and read and read. It is. I find defamation suits interesting. Was the reading too boring for you, Mousy? Because I know, like, it's so hard when somebody has to read 18 pages, but damn, that was well done. They should have put the disclaimer at the start of each episode. Yes. Or even just that one word. What do you guys think about that one word based on a true story? Changes the whole context, doesn't it? Like it just changes the whole, it covers them. And yeah, they did the disclaimer at the end, but isn't it too late? And who watches the end credits? I'm guilty of not. Okay, but I watch them with someone who loves watching the end credits to see who did the music, where it was filmed, looking for common names, common locations, things like that. Not me. I'm like, whoop, next, next, next. Like I'm a little too aggressive with the let's go forward button, you know? Hmm. But oh my goodness. All right. Thank you. I'm glad it was informative because that was my point. Although it's a little dry to read these kind of things, you know me, like I like to read. So I played it up. I probably mispronounced a few words, stuttered, but I don't care. The context of it was fantastic, right? And it should be. It should be informative. And the way the judge laid it out, point by point, how the like not just how he addresses it, but how the legal system, the judges in general, are supposed to take it point for point to help us further understand more of these civil defamation cases as they come forward. And I know you guys like that kind of stuff a little bit. Like some of you are just as nerdy as me, and be proud. There's nothing wrong with being a nerd. Okay. Nothing wrong at all. And I'm glad you found it interesting, guys, and informative, because that to me is the best compliments I could get, besides anything else. Let's see. Oh, I'm going forward. Claire, could you please put the link you shared earlier in the description or send it to me? Do you mean to the court listener or to the defamation? They're all in the description. They're all in the description, and I will send anybody who wants the document. I'll just put it up again. Hold on one second. I think I can get it for you really quick again. And you mean to the actual what I read? Could you just clarify that for me, that you mean the actual order from the judge that I read? Because everything else but the order is in the description. If you're still here, I know that was an actual a while ago, and you might not still be here. Well, just in case. Let's see. Order. Here it is. The one that was a shared link that everybody tests. Okay, let me just make sure the link is good. It is. This is the document that I read out loud to you guys, if that's what you mean. Charla, there you go. And to anybody else that wants it, did put it in earlier. That is not in the description. However, for free, the court listener site that's listed in the description has all of the documents. Okay, and just go to September 27th, and the document is there. For any reason the link doesn't work or anything like that, you know. And that is why I did not watermark this. This is free through court listener. There are some things listed there that say, you know, if you want it, you got to go to Pacer and pay for it. But anything that I get for free, I am also going to just like make sure that everybody else can get it, you know, right? Because I want you all to have the information. But for those of you more interested, it does list all of the case laws that prove point for point what people were saying. Okay, and whether the judge pulled the case law himself or he was using the plaintiff's or the defendant's case law in the argument, it's all there. And just for the record, if you highlight the case law, it actually has the paragraphs and all. And if you copy the whole thing and put it in your search bar, it will probably bring you right there on some document somewhere exactly for you. It saves you a lot of time. All right, look at that. I'm giving you a helpful tip on how to do this. Another person who is their own worst enemy. Unfortunately, that's a very true statement, Liam. She's not doing herself any favors, although she's fighting. You know, I do agree if she feels wrong, she should have a voice. I don't want to silence her. I just want her to apply her reasoning a little bit more specific, you know. And this is true. None of us are perfect. Also, there are no perfect victims, which is why those videos that I put down there are very interesting in keeping the discussion going about the topic of baby reindeer, about the topics that it covered and how well it did it. Okay, because honestly, guys, I want to talk to you more about that, not just the legal end of this. When this case is over, or maybe even before, especially around the holidays, if anybody wants to come to me and talk to me about their personal experiences or how they feel about some of these cases, their personal experiences in social media or anywhere else in regards to these topics, just let me know. I also have other shows like library chats where I'll do it, and everybody knows I like to talk, and I like to talk about a lot of different things. And I want everyone to have a voice. Now, that's not to say you're to come to my channel and turn it into a bitch rag session on somebody, because I don't do that, and y'all know that, okay? And I'm going to stick with that. But if you want to talk about the topic and the issue, I'm here. I'm definitely here. I love having open discussions in regards to this kind of stuff where people learn and grow. And that's always been my goal, okay? Mousy says he laid it out. I mean, she didn't have to come forward. I would never know who Fiona was. Exactly. But the judge did agree that once she did, there was no doubt that she was Martha. And from now on, the judge is going to say, Martha is Fiona. He said she basically proved it. Now, that's going to be a good point, Mousy, if you think about that. And everybody else in the chat, think about that for a moment. In proving whether there was real reputation damage or real damages occurred, how much of that was because Fiona decided to stay out here and deal with it? If she didn't, she wouldn't have any of this stress. She made it worse. And it's going to be up to Netflix et al. And their attorneys to actually prove that part of it. Okay? They're going to have to prove that. And they should start digging into her current presence in the socials in Scotland and London. Okay? I can imagine the get of all. I know there are a lot of defamation suits in California. The people who harassed her are no better and should be ashamed. They think they're justified vigilantes, even though they're just vindictive gits who stuck their noses into someone else's. But exactly, because that part there, you know, about the cyber sleuths, those are not reasonable people. I agree. Some of the people involved in true crime and advocacy. Some of them went forward and attacked her because he was saying that it was abusive and that there was an assault there. And so they were like, did you do that? Like, what kind of an awful person are you? But then again, Fiona is making more of it than it is. Like, she's actually gone forward and said there were death threats that I didn't see. Like, I didn't see any death threats. And basically, the things that she was mostly accused of were the actual stalking. People just saying, can't you just leave people alone? Nobody wants to hear your opinion. Like, you're out here forcing your opinion on people about other people, not about issues, topics, or situations. We're talking about other people. Anybody remember the Eleanor Roosevelt quote, you know, about the levels of people in conversations? Go look it up. It's priceless. And I stick by that. That's why on this channel, we follow the Roosevelt rule. Okay. In most cases, we will talk about a big, big celebrity and not cause them any real harm. And we do make fun of social media situations. Yes, we do. But do we target individuals that aren't, part of all of that? Hell no. There's no time for that. There's too many other things to talk about in this world, and I would rather do it. Did you watch the series Snippet? I'm so glad. I can't wait to talk to you about it. Like, because I just loved Baby Reindeer. I absolutely did. Hey, Record is still hanging out. To reference CHL, Fiona should piss off. When she gets there, she should piss off again. Wait a minute now. Oh, Mousy, thank you. You said my reading was great. I appreciate that, love. Thank you. Thank you. Thank you. Did you learn to Mippet? I'm so pleased. You guys are making me so happy. I'm going to be doing the 20-minute regard, the 20-minute goodbye because you made me so happy. Like, how far can these disputes go? I mean, if you change the names and no one knows it's you. Exactly. Like, that's the point. Where in law does it say it's Netflix was responsible to do that? That is what has to be proved in court. Now, the judge isn't saying that Fiona won. The judge clearly said it was a matter of law to be proved one way or the other. That there wasn't a law that says it should just be tossed because it had no merit. That's what the judge said. Every time he granted to Fiona to keep her intentional infliction of emotional damage in her defamation, he's saying, now it's up to you to prove it to a jury. It's a matter of law, okay, for you to prove it. There's just not enough law for me to toss it because you got some points here. But he also said the defendants had some points there, okay? He just doesn't have enough to throw it out under anti-slapp, okay? Although he did point out some good failings in Netflix's argument, Oh, thank you, Karen. Karen, if you have a short story, like I'll do them 20 pages or less, let me know. You got a favorite you want read. I love to read. As a matter of fact, I'm going to be working on the House of Usher for Halloween again. We have art from Reverend Ruin that I bought years ago when I planned to put this out, and then something happened with my voice, and I didn't have the right audio equipment, and I was never happy with it. I was thrilled with Reverend Ruin's artwork, absolutely thrilled and inspired by it, but it was me. I delayed it like incessantly. But this Halloween is coming out. I always wanted to bring it out on Halloween. I missed last Halloween because I got ill, and this Halloween I'm getting it out. I'm going to do it early. Oh, thanks, guys. I can't read all of these nice compliments. Okay, we're going to wrap it up with the moral of the story from Paula here. The moral of the story is that we are all responsible for our own actions. Don't be a creep if you don't want to be called out for being a creep. Paula, I can't tell you how much I love you and how you just wrapped it up like so beautifully. That is absolutely beautiful. I wonder how fast she's going to get sued for stalking if she wins some money. I would say pretty fast. I have been watching the circuit of social medias and also the interview circuit and the article circuit in the UK. And Laura Ray and several others have put out such a case that many people are arguing that they should actually come forward with their actual complaints about Fiona Harvey, that she's been getting away with this. People felt a little trying to do the right thing by saying she obviously has a problem and we don't want to ruin the rest of her life. She doesn't stop. She takes that gift that they gave her and she goes on to the next person and does it all over again. And now they are seeing the pattern. Okay. And that's a problem for Fiona Harvey because apparently her behavior has not stopped. She lies. She got caught in several lies on Piers Morgan. And I'm wondering if that interview is going to come into the actual evidence because we have to get to discovery yet and evidence. And wow, oh wow, what are they going to bring in? If they bring in the fact that how can you believe her about emotional distress when she's out here calling Gada every name in the book, taking swipes at him whenever she can, insulting him still to this day, just last week. When they got the Emmys, all she could was say every awful thing she possibly could about all of them. She never has a nice thing to say, ever. No, she's entitled to her opinion. But wouldn't it be funny if Gad, like, I don't think he wants to deal with her, but wouldn't it be funny if he then turned around and sued her? Ooh, mm. It's going to be a very hard case. And was it worth coming forward? I think in the position that she's in, knowing that they made all the money, whatever she gets, she's going to feel it was worth it. But also in actually the anti-slap and in her punitive damage charges, she was looking for in her opposition to the anti-slap, she requested attorney fees because she said them filing the anti-slap, like there's a clause in there, that if it became no merit, that she would get the attorney fees for the portion that she needed to defend against the anti-slap. But the judge did kind of knock that down in a separate order since he knocked out the punitive damage in several of the cases, meant that the anti-slap was not frivolous in itself and that her actual claims for damages in certain areas were the frivolous part. So she was denied any reimbursement of attorney fees in regards to the whole anti-slap situation. Not the lawsuit, just that portion. So I'm glad you actually put that question in there because it reminded me. I wanted to tell you guys that, you know. Don't get me wrong. If she was wrongly accused, really messed up. But if she really stalking this guy, then leave him alone. Not only this guy, it's fact. They have orders on her in articles. She stalked the Rays. She stalked the War. She stalked Richard Gadd. He got an order on her. There's documentation of him in contact with the police. The owner of the bar he worked at came forward. People that worked with him came forward and gave affidavits. It's that part of the story is true. Her coming into the bar, meeting him, and becoming infatuated, or let's say attached to him in a certain way. It started then, and they all were there. They all gave affidavits of witnessing her there before they opened, that he had to go through the back entrance. They had to sneak him in. He often complained of the calls and the emails. He never answered her. I mean, having all those emails and phone calls over that many years and you didn't get a response to not one return email, text, or phone call, not one response. What does that tell you if somebody's doing that for 4 years? Oh, she's guilty of stalking, just never got prosecuted. Exactly. And that's why I found it fascinating when Oakley came forward and said, yeah, but if they did actually press charges, she would have got 5 years. So they didn't lie about that. They just lied about the fact that the process got that far, like that she did it. But that's her point. She's really obsessed with the fact that she might have, like, people might believe she has a criminal record. But becoming back in the public eye like that, she may have risked it that she will end up with a criminal record to some degree. If one of her other stalkers come forwards and decides to press charges on her, she could end up with the criminal record through her own fault of coming forward and making herself a very popular name everywhere right now in regards to this case. That doesn't mean she doesn't have a right to defend herself. I'm not saying that. I'm just saying through this action, she could have put a spotlight on herself she doesn't necessarily want. It's kind of that saying, like, be careful what you ask for. You just might get it, but it might not be exactly what you thought it was. Oh, hey, Sean. I'm so glad to see everybody like just being so supportive and great in the chat. But on that, unless you have any other questions, I think that I covered it all. Yeah, you know, I think that's it. I'm glad you all learned something. You made me feel really great by saying that, in that you liked the way the guy laid it out and it was informative and you actually got something out of this. That makes me feel good. People like her are always obsessed with the facts as they see them and how they affect themselves. Exactly. Well, thank you very much, Mouse. All right, so not so bad for a pull it out of my kind of presentation because I had nothing for you as of yesterday morning. But damn, I'm glad that we did this. Thank you guys. You've encouraged me. I'm coming back tomorrow afternoon with an earlier one. I've been doing those on Wednesdays, and since Milton has gave me some time on my hand, we will be talking about a couple others tomorrow, and one of them is going to be Boone. There were more filings in Sarah Boone. Yes. Yes, there were. And with your graces, we'll be reading those tomorrow. So buckle up, buttercups. Have a great night. And I can't wait to talk to you again. Remember, don't forget to like, share, and comment. If you think of something you didn't ask me or you didn't bring up or you want to talk about, please hit the comments. My comment section is lonely, people. There are dust balls and tumble dust bunnies, tumbleweeds, you name it, blowing around over there in my comment section. Like, because you've been coming in gratefully and talking with me every day while I do these lives. But still, Sarah Loon? No, did you just say that? No, not Sarah Loon. Sarah Boone. Did I say Loon? Oh my God. That would have been something. Like what a Freudian slip. Paula says, I'm going to put this up because this is just lovely. This is such a special community of like-minded individuals. We have connected in a unique way. I live a life of passion and humor. My defense mechanism? Yes. Finding people that get it is priceless. Thank you, Paula. And you all. Thank you all for making that community. Okay. Thank you so much. Like Record said, hit that like button. Come talk to me. Everybody have a fantastic night. And hopefully I will see you tomorrow. Those of you that aren't working or whatever could check in. If you can't, hey, I hope you check the replay. I'll talk to you later.